One of the most common problems that I see amongst lawyers who appear regularly in front of judges is that they fall into the trap of thinking that because a judge has always denied a certain motion, a certain issue, handled things a certain way, they just decide, hey, I'm no longer going to pursue that issue with the judge anymore. And as a result of that, they kind of give up on some issues that they are otherwise convinced are extremely viable. For example, I had a case in Macon not too long ago where I was arguing about whether or not my client's refusal to submit to a breath test in the case was in fact admissible against my client. I raised the issues that are being litigated and were litigated before the Georgia Supreme Court in Elliott v. State. I kept arguing that issue, kept preserving those issues. In each one of those cases, I ultimately obtained a non-DUI disposition out of them. And what I want you to know is that if I had just given up because the judge on those previous cases had said, you know what, after the first one, I'm going to deny this motion, if I had just said, well, I already know what the judge is going to do, there's no reason to do it. What I would have done is I would have lost the leverage that I otherwise had with those issues. So if you have a judge who has decided for whatever reason they're going to deny a motion that you believe is viable, and you have other cases with the same issue in them, continue to raise those. Do not give up on it. Let the appellate process work out. Don't waive the issue for your other clients. Don't give up just because you know what the judge is probably going to do. And in fact, it becomes a lot easier to simply go forward with the issue, preserve it after the judge has already made up his mind, so to speak. So if you have a judge who's already expressed an opinion about a certain issue, all you got to do is walk in and say, well, Judge, you heard this issue in so-and-so's case. I argued on whatever date. I just want to preserve the same argument for the purpose of the record. This is what my argument is. This is what the issue is. And you can basically even stipulate to the facts that you need that are relevant to the motion. So that's really easy to preserve it and not waive it in your future cases, rather than simply saying, I'm going to withdraw it because I know what you're going to do. Don't do that. Don't let them off the hook that easy. There's no reason to do that. If you truly believe the issue is viable, particularly if the issue is already pending in other cases on appeal, you should absolutely preserve it. There's no harm whatsoever in it. You certainly aren't going to upset someone by arguing a motion that's on stipulated facts. So do it. There's no reason whatsoever to give in on it. If you have any questions, feel free to call me. My name is Ben Sessions. My phone number is 470-225-7710. Again, 470-225-7710. Thank you.